Good afternoon, all. This hearing is in the matter of CFI 020-2023 and CFI 061-2024 and is being held by way of video conference before Justice Lord Angus Glennie, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant in the lead claim is represented by NHB Legal. Lead counsel is Mr. Amr Bajamal. The defendant in the lead claim is Belson's Innovations Technologies, who is being represented by an employee of the company, Mr. Kamal Trafi. And the second defendant in the consolidated claim, Mr. Asad Khan, is a self-represented litigant in person. Thank you.
Yes. Well, good morning. Mr. Asad Khan, you're representing yourself, are you? You're muted. I can't hear.
Sorry. Good morning, Your Excellency. Yes, I'm represented myself, and since I'm listed one of the case parties on CFI 061-2024, that's the reason why I wanted to join this hearing.
Yes, thank you.
Thank you.
Your Honor, if I may raise a comment on this point.
Yes.
Today's hearing is to hear the application for permission to appeal and
Yes.
Our application for the unless order.
Yeah.
And Mr. Khan is not a party to neither of these applications. He was made a party by way of a new claim that was filed by Belson's, and that claim was said to be joined or merged with these proceedings. However, he has no standing when it comes to these particular applications. I understand that this is a public hearing and he may attend if he wishes. However, I would like to question why would he need to make submissions to the court?
Well, if as I understand it, the two sets of proceedings have been joined together. He is therefore a party or representing a party to the joint proceedings, and although he has no direct interest in the particular issues, he's entitled to be here, and if anything arises which affects his interests, he's entitled to speak about that. But I agree, he doesn't have, as I would understand it, a direct right to argue about the two particular matters in dispute, but he's entitled to protect his position.
Thank you, that's clear.
Thank you. Now, how are we going to start this? Mr. Bajamal, do you want to start off, or should I ask Mr. Trapi?
If I I think as a matter of good order, it would be useful to deal with the permission to appeal application first, and then the unless order. And in that regard, it is Mr. Trapi's application, so I think he should start.
Mr. Trafi, can you keep your camera on, please?
Yes, Your Honor.
Otherwise, I can't tell whether you're there or not.
Yes, Your Honor.
One of the two matters today, as you probably heard Mr. Bajamal say, is your application for permission to appeal against an order I made back in August, I think it was. Do you want to start on that?
Oh, it's as I pay by law, so the claimant has to explain first. After that, we can check the person to answer again, because by the law, the claimant was the one who made the request.
Sorry, I'm not with you. Can we just start? You represent Belson's, is that right?
Yeah, Belson's, yes.
Yeah, and you are an employee of Belson's?
Yes, I'm their legal consultant.
You're the legal counsel to them. But the order made against Belson's, which you are seeking to appeal, is the one in which I allowed the change of name of parties.
Yes.
And and reiterated certain other orders that had already been made.
Okay. As there is a case against from Muzoon company against INFOTECH and others.
Yeah.
So right now we have another party. So Mr. Asad Khan is one of the other parties, and is the one who presented before the INFOTECH company, ELINX company.
Yeah.
So I want to start by him, because previously he is the one who deal with the company under the contract from 2022, and already we have more judgments coming from the the IFC, means that all these cases requested today is all dismissed, and this case is only repeated and lose of time. So legally, I give the others, Mr. Asatan, to explain about what happened.
Well, what I want to know from you is to hear your arguments about your application for permission to appeal. And before I do that, though, have you as yet entered acknowledged service in these proceedings?
Yeah.
When did you do that?
Yeah, next last time we applied for that.
Sorry.
Last time, so we given an application against the three parties.
But I understood that you hadn't yet acknowledged service, formally acknowledged service in terms of the rules of court. Have you done that?
Yeah, already done.
What day was that done?
Done last week.
Right. Okay, I'll perhaps ask the court.
November 13 November.
All right. Okay, so you've acknowledged service, and you're applying for permission to appeal. Is it all aspects of the order you're applying for? Want to appeal?
Yes, Your Honor.
I'm sorry to interrupt, Your Honor. You may be referring to Mr. Asad Khan when you referred to the lack of acknowledgement of service. So he is the party that has not filed the acknowledgement of service yet.
I'm sorry. Thank you very much. Can I just check? I'll just check that. Mr. Asad Khan, have you yet entered an acknowledgement of service?
So I tried to create a new account, Your Excellency, and when I try to file the acknowledgement of service, I can select the case number by the drop down there, but no case shows up there. And that's the reason why I submitted my memo via an email to the DIFCE registry, my memo and the supporting documents.
Perhaps after this hearing, you can liaise with the court officials, and they may help you. Alia, can you, after this hearing, could you help Mr. Asad Khan to acknowledge service in the formal way?
Yes, of course.
Thank you.
And if I may, if you have any questions regarding the application, I think I'm happy to talk about it here.
Which application are you talking about, Mr. Khan?
I had in reference to the PTI application and the claim CFI 061/2024. I had submitted my response via an email since I could not file the application via the portal. And what it says was the PTI itself, when they filed the claim, there was no notice that was sent to me as a case party. And absolutely no information about it. And I received a notice only after the judgment.
Mr. Khan, I'm puzzled about this. The order I made, which is the subject of the application for permission to appeal, was the order in CFI 020/2023, which is a case by Muzoon against Belsons.
Right.
Yeah. You're not a party to that.
I'm not a party to that, but under that order it says CFI 061, in which I am a party to that, and anything regarding the claim or the application, I did not receive any notice on 061.
Yes, but the relevant part of the order which is being appealed against does not concern 061.
Okay, I see. Then in that case,
I don't think so. Anyway, maybe someone will be. I'll just check on this, Mr. Bajamal. The order I made, Mr. Traffy, can you keep your camera on, please? If you can keep your camera on, it means I know who is present in the hearing. Mr. Bajamal, the order that we're talking about, which I made, I think it was in August, was it?
Correct. The order was made on the 16th of August.
Yes.
And
what page?
You are right.
What page is that in your bundle?
It is on page 104.
Yeah. And
so you are correct, Your Honor. This order was made in the first set of proceedings in the CFI 20.
Yep. And does the other action get mentioned at all in this order?
No, I believe it didn't exist at the time.
But there was a different order which allowed the actions to be joined together.
Yes.
Well, it is the same order, Your Honor. The order addressed multiple issues, and one of them was the access, and one of them was the change of name and contact details.
Yes, but in addition, there's a change of name and contact details, and there's the access to the software. Those are all covered by the order of 16th July 2024.
Correct. And then there was a subsequent order for the merger and calling for this hearing.
What date was that order?
I will.
24th of October.
The 24th of October.
But that is not subject to any appeal at the moment.
No, it's not.
No. Okay, that's useful. Now, Mr. Traffy.
Yes.
As I understand it,
Yeah.
Mr. Asad Khan does not have any legitimate interest in challenging this order of 16th August. It's your application to appeal for permission to appeal this order, and so you've got to tell me why I should grant permission to appeal.
Okay.
So can you help me on that?
Yeah, yes. So as we send by documents, Mr. Asad Khan has some conflict between him and the company Wilsons, like a contract. So there is a criminal case against him and others. Like before, is the owner of the company ELINX, which now is Wilsons. And we got strictly information from public prosecution, then we cannot get any access to the software because he's responsible of that, and he's the one technical. He's the engineer who want to explain for the job done and everything passing in the past with the ELINX company.
Can we stop for a moment and just go back slightly? Do you have a copy of the order we're talking about, the 16th August order?
Yes, we have already.
You have a copy of it.
Yes.
I just want to make sure I understand which parts you're challenging and which parts you are not challenging, if any. So paragraph 2 allows the change of name of the defendants. Do you challenge that?
Yes.
Why do you challenge that?
Because of the criminal case was before in the public prosecution, the class instruction, and not prohibited that for giving software to everyone till the case finish.
Well, that if I may say so, that's talking about access to the software.
Yeah.
But this is a separate part of the order, which allows the change of name.
Yes, yes. But till now, we appeal the judgment that ELINX, it's not it's a Belsons, right? But historically, ELINX it's INFOTECH. So it is the one who is responsible for all work done and the contract signed and everything.
Right.
So I mean that the question that we have to ask for the previous Asad Khan as like a manager, because there is another party should be present today, is the Bianca. Till now is the partner of Mr. Hamza, the owner of Belsons.
Yeah.
So right now there is a cooperate and change from, because actually the software is focusing and coming from UK, and who's the one who do from the resource is the owner, the first owner who's signing the contract till now, and this is which the problem is it's coming till now a conflict different between us and the Bianca, the owner of previous company ELINX, and still in Dubai court like a criminal case, and we have to go ahead for that to explain that we are not concerning in this matter. So we are Belson's company, and we are not as you know, the law previously is coming for the old law. There is 2 cases already. The judgment is already there, so it means that the case dismissed. So we are not responsible for any criminal, any responsibility, civil or other responsibility.
But am I concerned with that? Because in terms of the change of name, the claimant is entitled to sue who he wants to sue. If he's got it wrong, it's his fault. He suffers the consequence if he's got it wrong. But if he's persuaded me to make an order changing the defendant's name, what is wrong with that?
Wrong because we are not anymore ELINX, because Belsons is a big company. Under this company there is many branch. Belsons for the contract saying that Belsons is managing ELINX in UK, in India, in Egypt. So the previous all the contracts before, it was between Muzoon company and the third party, means that name is Sharaf, and ELINX company, which is honored by Bianca, is not other Asad Khan. Asad Khan he has a power of attorney. So now, only his presence is like someone who power of attorney from getting the power of attorney from the owner, which is outside of country, and he's the one who dealing or managing the company in UK. So it means that ELINX, it's not ELINX in this period till 23-24. Just we register our intellectual property under Belson's name. That software is contributing for us. But before that, we are not responsible for nothing legally.
That might, if you're right, that might be a defense to the action. But all we're talking about at the moment is changing the name of the defendant.
Yeah. Again, so, Your Honor.
Yeah.
Again, Your Honor, I cannot.
See, sorry. All I was saying was the points you make may be relevant to a defense to the action against Belsons, but we're not at that stage yet. We're simply at the stage, so far as this part is concerned, we're simply at the stage of identifying the name of the company that the claimant wants to bring proceedings against. And
Yeah.
if he wants to bring proceedings against Belson's, what is the legal argument to say he shouldn't be allowed to do that? You may have a defense.
Yeah, the electoral property. So I already attached in by documents that we registered the company in 2024.
Yeah.
Under the name from Ministry of Economic. So this shortly, this it's clearly legally proof that we are not relative to the website aims call it the EMPS. So it's coming from UK and contains to ELINX company before.
But that may give you a good defense if you're right. But why does it stop the amendment to change the name of the defendant? I mean, if my order allowing the change of name does not mean that I'm finding Belson's to be liable. I'm simply finding them to be acceptable as a defendant to the proceedings.
Yeah, because we sell the company, and because there is a branch, all the works in UK, India, and Egypt.
Yeah.
So I mean that we have to change the name under, because as you say, Your Honor, that Belson's is a group of companies and is registered in the IFC, and which we thought ELINX is a company registered by economic departments here. So as Belson's as a big company and registered in the IFC, and they have branches all the world. So means that the procedure for facilities and make everything easy to our cooperation and the future contract with the others. So means that we change the name for that the commercial name, and because we are the one we sell the company, and there is a contract between us and the previous company ELINX LLC.
The name of the application to change the name of the defendant arose out of it being said that ELINX INFOTECH had changed its name to Belson's.
Yeah.
And you don't disagree with that, do you?
Yeah, we did according to UAE law, and so there is a registration in Ministry of Economic, as well. There is a registration in economic department also, like actually properties.
Right. Okay, but
this is our dependent by documents.
Sorry.
There is our dependent by documents, and documents is already attached to the file, showing that the changements happened in the economy department, and the ministry is already by documents, and mentioned that we are responsible from the dates which were mentioned, 2024. And that conflict, that problem is happened in 21, 22, and 2023. And we have already some judgments that the case is dismissed. And as well, ELINX, the one is win the case before. So it means that we are not concerned about this. And even with that, we didn't get any money from the Muzoon, and we don't have any relationship with Muzoon. We don't know this Muzoon, and we don't know in our accountability. There is no money coming to us. Even we hired some expert, there is no money coming inside our accountabilities. Mentioned that we got some money from Muzoon as well, from ELINX, from Sharaf, the third party. That's why, Your Honorable, so we make a case against the three parties. If you provide that ELINX that Belson's, so that time, so Muzoon and Asad Khan and Bianca presenting ELINX INFOTECH, and Sharaf, this third party. That's why the case is dismissed. So we have to give all money to us, because we don't receive any money from that. And with the contract, with the company, when we buy and sell company with the contract, there is no mention, there is no money mentioned in the transfer from the company ELINX to Bilsons. So this is, Your Honor, what we have to add to you.
Yes, I see.
Yeah.
Mr. Bajamal, do you want to help on this point?
I think the point that is being made, if I understand it correctly, is that there are two separate companies. One is Belsons and one is INFOTECH, ELINX. And I believe our position is that this is completely false, because I would like to take Your Honor to page 94 of the bundle.
Yep.
So this is a copy of the trade license of before the change of the name. And if we look at in the middle, it has a license number that ends in 71.
Yep.
And if I could take Your Honor to page 98 of the bundle, this is an extract from the Ministry of Economy's business license details for the same company. This extract was issued on the 7th of September 2024.
Yes.
And if we look at the license number at the top left-hand side, we can see that it is identical to the
538071. Yeah.
Correct. And then if we look at the name, it says that the current name is Belsons Innovations Technologies. Yeah. So, you know, the public record speaks for itself on this point. And it is the same incorporation date of 2002 and same activities. So by all means, you know, the simple fact is that ELINX changed its name to Belsons. And this was admitted by Mr. Batrawi over correspondence to the court when he first came in. And also, Mr. Batrawi himself signed the consent order with us with this name after he came on board as a representative of this entity.
Yes.
So it's not clear on what basis all of these arguments are being made.
But the other thing, Mr. Bajamal, is surely this, that all the order does is allow you to change the name. It doesn't say you are right. It says
absolutely.
And so if there is a good point that is not the right company, that can be a defense.
I completely agree, Your Honor.
Yeah. Well, Mr. Traffy, just on this question of change of name, it's my fault, I expect, but Mr. Bajamal has explained that the documentation that he's shown me shows that the same company license number, same license number is used for ELINX INFOTECH as well as for Belsons, and that suggests that they are the same company. Now he is suing the company in the name that he thinks is appropriate, and I made the order allowing that change to happen. If you have a defense to say it's a different company, that's the matter you can raise in your defense.
Okay, the rules, Your Honor, the rules in UAE in economic of departments. So if any company change the name, not change the article name or the logo name, so you should be in economic department. And so for proving that, so why I want you, Your Honor, to ask the claimants. So why, if they have this document, why they make case first time registration and in the bundle case and the request of that under the name of ELINX and not make the case under the name of Belsons? This is my question.
Why does that matter? You disappeared, Mr. Traffy. Why does that matter?
The matter is that before the company Muzoon knows that the ELINX company is already make that conflict before 2 cases and they lose. Now they try to change the name under Belson's, under the new rules and the new management to prove that there is another problems happens. But in documents we are already mentioned that everything is delivered and finished by the old company ELINX.
Right. Well, on this question, I've heard what you say, but I see no basis for allowing leave to appeal on this aspect of the order. So I'm proposed to refuse your application for permission to appeal on that aspect. Do you want to tell me about other aspects of the order? I think your point is that you can't. If we just go back to the order, which is at page 104. Hang on a second.
So, Your Honor, we refuse that we are ELINX. There is also in Ministry of Economic that there is a registrement mentioned in documents that the company is under the Belson's company under 13/7 July of 2024. So you can see that in our documents attached.
What page of your documents?
And the company is not about the name; it's about the software. So the main problem is the software, but software is registered in 17/7 July 2024. So it means the main problem in this case is the software. It's not the company or name. Even we had to take the company ELINX that Belson's. So we're talking about software. Software is that kind of company is buying the software. Software who's the ruling and by the law. So if you check your owner the registration of software under Belson's company, it will clearly mention that the Belson's company even change Belson or X or Y. So there is no matter. The software, the main problem is under Belson's company in the date of July 2024. So even it's not matter to change ELINX or Belson's is the same. So software is not under our our responsibility. Even like ELINX or even like Belson, so it's the same. And as you said, Your Honor, as already there is 2 cases against ELINX, against this software, at the both of cases is already dismissed. So it means that legally the case is dismissed. So we cannot make another case in the same object and in the same object in the same parties. That's what the claimant tried to do. That now they try to change the company name by another one to try to reactive and to make another claim against the Belsons, which is not responsible for nothing, and he didn't know about what work done or what is the ELINX company. So this is our Your Honor.
Okay, I think what you say, I think I understand the point you're making, but the fact is, this is only a question of whether I should grant permission to appeal against an order I made in August. And I need some good reasons as to why I should give permission to appeal. And the fact that you say a case has been dismissed, that may be something you can put in your defense, but it doesn't affect this application.
There is 2 judgments, sir.
Which 2 judgments of which court?
Court in the same court, the instance, the small claim. So Mr. Assad knows about this because he's the one to represent ELINX that time. So I addressed the question to Mr. Assad because he's the one who did these 2 cases under his name. He's the one who make the software. He's the one who make the work. So my question, I will transfer to him to answer your honor.
The argument that the small claims court determined this claim is already been tried and it was rejected by another judge of this court.
Yeah. Yeah, it's already dismissed. It means that the case is over. So there is nothing to see with IMS, because already also there is a signature that work is done and finished. And Mr. Assad, like because he's the engineer of the INFOTECH before, so he's the one who was present and defended the ELINX company. And if you ask us like ELINX company, so we should address to him historically what happened before, because he is also responsible if we that ELINX is the same bill funds. Okay, so your honor, you can address it to Mr. Assad. He can mention the two cases that the claimant is already dismissed and refused by the IFC court in the name of 2022.
Mr. Trafi, I think I know what you're referring to. Small claims court decisions dismissing a case, but the judge, Justice Wayne Martin, as he was, rejected the argument that disposed of this claim. I think I'm right in saying.
Yes, but there is the second case also.
What is the second case?
That's what I'm asking Mr. Assad to answer this, because there is two cases, and he's making as well. If you can check.
This is your, Mr. Trafi. This is your application for permission to appeal.
Yes.
I want to hear your arguments. Yes.
Yeah, because if you see, like, because Mr. Assad, like other is a part of a part. He sent one application to the DIFC court to get in the certificate of the winning the case, certificate of services, and certificate of the costs, because he win the case. So I mean that there is a case already finished actually in the subject.
Mr. Bajamal, are you able to help on this one?
I believe Mr. Trafi is referring to the cost order that was given to Muzoon on the back of having successfully defended the application for immediate judgment.
Yeah.
But I don't see how is that helpful to his position.
This was a judgment refusing immediate judgment.
Correct. So there are two outstanding cost orders in these proceedings. One of them relates to our costs in relation to the immediate judgment application, and the second is in relation to the order itself of the 16th of August, and both of them are irrelevant as to the application for permission to appeal.
Yeah. Well, Mr. Trafi.
Yes.
At the moment, I am not persuaded there is any basis on which I could properly grant permission to appeal. What I would propose to do is to refuse the application for permission to appeal and allow you have the right to apply to the Court of Appeal itself and persuade the court that I'm wrong to refuse permission. But my decision on this point is to refuse your application for permission to appeal. Do you understand?
Yes.
But just to be clear, you can check with the registry afterwards, but you have a right to apply to challenge that decision of mine by going to the Court of Appeal and persuading them to grant permission. And it's not for me to comment upon what they would say. But my decision is to refuse permission to appeal. All right?
Yeah, okay, correct. So now, so they have to correct also in the request. That's the others. Your honor, you can mention the others means, because in the claimant is Bilsons against Muzoon against Bilsons and others. So, Your Honor, if in your judgment, we need to know which is the others, because if we
what others?
Others means the other. So Muzoon against the Bilsons and others. This is the claimant request. So others means that there is a third party, Sharaf, and if we consider that as a ELINX company.
Hang on, there is no, in the application I'm dealing with, is in action CFI 020-2023, and is an action by Muzoon against Belsons. No, there's no reference to others.
No, there is the other case now. All requests and bundles is mentioned, and all the registration comes coming that Muzoon against ELINX and others. Your Honor, we need to understand others.
I don't know what you're talking. I'm only talking about one application in one action, and that is the action between Muzoon Holdings and Belsons, and the only named defendant is Belsons in that action. That's the only application. That's the only order I'm concerned about. And if you want to ask other questions, then there are ways of doing that in the court process.
Yeah. So as Your Honor, your judgment to be that the Belsons means ELINX, that is Belsons, is only in the name of that.
The whole of the order. You're applying for permission to appeal against my order of 16th August. I'm refusing to give permission to appeal. That covers the whole of that order.
Appeal, Your Honor, for the name, only for the name, right?
No, the whole of that order. If you look at the order, do you have it there?
I did make the order that we are not ELINX. That is our appeal.
It's the one you're asking for permission to appeal, and the order gives permission to change the name to Belsons, and also orders the claimant, the defendant Belsons, to grant access to the software by a certain date, and then it deals with service of expert reports and so on. I'm refusing permission to appeal that order. And if you wanted to take it further, that's a matter for you. Okay.
Okay. So and we have to add the third party as the others. We have to add some like ELINX or
if you want to add anyone, you can make an application in the proper way.
Yeah, we'll make, Your Honor. Yeah, we make an application. The others means that ELINX and Sharaf and
that's for you. That's not for this hearing.
Yeah, after the judgment for that, if you accept, Your Honor, that accept that Belsons is ELINX, no, we have to mention the others. The others means ELINX and Sharaf.
Mr. Traffy, there's no misunderstanding. There may be a misunderstanding. I am not accepting that Belsons and ELINX are the same. I am simply allowing the claimant to make that case.
Yeah, okay.
In due course, who knows what will happen.
Okay.
Okay. So I'm refusing the application for permission to appeal. Now, Mr. Bajamal, that's dealt with that aspect of the thing. You now want an order which I now can't find the reference to. Where is the order you want?
Perhaps, Your Honor, can we have a 5-minute break, and then we can start with the unless application?
Yes. Can you remind me what page the unless application is?
Yes.
It's about page 4 or something, isn't it?
Well, the claim form is at page 4.
Yeah. Where's the unless application?
Just one moment. It is at page 48 of the bundle, Your Honor.
Yeah, okay, I have it. So you want 5-minute break, do you?
Yes, please.
Right. 5 minutes enough, or do you want to make it 10 minutes?
I'm happy with that.
Let's make it. We'll have a. What we'll do is we'll if everyone can go, just mute their microphones and cut the camera, and we'll resume in 10 minutes time. All right.
Thank you, Your Honor.
Thank you.
Thank you. Yes, are we all back? Mr.
Yes, Your Honor.
Mr. Bajamal.
Thank you, Your Honor. I would like to just say a closing point with regards to the permission to appeal. I'm requesting the court to grant us as well our costs with regards to defending that application since it was dismissed.
Yes, Mr. Trafi, can you object to that? Talking about the cost of the application on your part for permission to appeal. You've gone sideways, Mr. Trafi. Can you change your camera so it's Mr. Trafi? Mr. Trafi, are you there? That's better.
Yes, sir. Yes, sir. So,
Mr. Bajamal is on the question of the matter I've just decided about refusing your application for permission to appeal. Mr. Bajamal wants his costs of that application. Can you oppose that?
yeah, no, we don't accept this cost because the cost is we have to appeal this cost. So we don't agree about this cost.
Okay. Well, is a normal thing. The normal thing is that the losing party would pay the costs of that application. So I'm going to award. We're going to refuse your application for permission to appeal and award the claimant the costs of that application to be taxed by to be assessed by the registrar if not agreed. And you,
Okay, so
you can.
Yeah, you can. So we will appeal about this cost because we're not relative of that. So actually, we're still in the case, and as like there is a judgment mentioned that all cases now it's attached between all. So we don't have to pay anything after we start to see about the object of this case. So the cost and everything, because till now we didn't have any relationship with it. We didn't receive any money. We didn't have any accountability for that. So even when the judgments come, or as well software, we have to call Mr. Asad Khan and Bianca and UK. So the others now we have to let Mr. Baljaman, the claimant, to mention with whom do the contract and with whom pay the money and who is the Sharaf DG and where is the money, why they ask for the software, what the problem of software and why they didn't complain before, and what is about the case is dismissed before. So we have to discuss all matter of this point. So till now, there is nothing to pay until to clarify everything, and we see and to call the others. What does this mean by the others? Others means in the case number which request which do 61. We asking Muzoon and we asking Asad Khan and Bianca and we asking Sharaf DG because this is the part of this job and all of these cases.
Well,
okay, so now you're honor to decide.
If you want to do that, there are ways within the rules of court to enable you to take steps. So I'm not going to get involved in that at the moment. Mr. Bajamal, you can have the costs of the defendant's application.
Thank you.
To be assessed by the registrar if not agreed. Yes.
Thank you. Yes, Your Honor. So I'll carry on with the unless application.
Yes.
So as a general note, Your Honor will take note that this application is uncontested because the defendant did not file any evidence in response. So
Yeah.
to that effect, I'm going to take Your Honor through historical background as to how we got here. And then my position is that since it's uncontested, Mr. Trafi should not be allowed to make submissions to the court on the application.
I'm not going to stop him making submissions. Let's be realistic about this. But I also have a document which I think you've seen already. It's called is headed with Belson's Technologies and subject to appeal of order of justice, claim number. This document here. Can you see it?
Yes.
Yes. I think that contains aspects of what the what Mr. Trafi would want to say.
Yes, I'm aware of this document, and we've made arguments against its admission in our skeleton. But if Your Honor is inclined to let it be admitted, then my arguments are in the skeleton, and I understand the decision. So I would go straight into making my submissions.
Yes.
So by way of background, the matter started with a case management order that was made on the 10th of May, 2024. At the outset of these proceedings, both parties had discussions prior to the CMC. And during those discussions, it was agreed between us and Mr. Khan, being the representative of the defendant at the time, that it would be helpful for the court to appoint a court-appointed expert and to give evidence on the sufficiency of the software and the functions and so on. During the case management conference, the honorable judge at the time disagreed with our approach.
Which judge?
Judge Al-Nasser.
Yeah.
Yes. So we both parties at the time applied to or suggested that a joint expert appointed by the court is to be appointed, and we pointed out to the relevant RDC rule, which does allow the IFC court to exercise this power.
Yeah.
The honorable judge disagreed and directed the parties to rather appoint each party to appoint its own expert, and then the court would hear the evidence that way. Yeah. As a result of these directions, the parties then had further discussions and mutually agreed amendments to the CMC order, and it was submitted by way of the parties' consent, and the registry issued it on the 10th of May 2024. Yeah. That order contained provisions for submissions of expert reports. Yeah. So when the time came for the experts to start work, we reached out to Mr. Khan and informed him that in order for our expert to prepare his report, we would need him to get access to the software. And we informed him that our client was not able to access the software because a message comes up that says that it's in need of an update. Mr. Khan said that yes, that this is true, that there is an update that needs to be installed for it to be accessed, and he informed us that in order for this update to take place, that they need to be given access to Muzoon's server, and in order to install the update. So we agreed to give that access to the server after consulting with the IT experts. Mr. Khan then agreed to provide access by a certain date, and that was signed in a consent order. Before that date approached, Mr. Khan then communicated his updated position to the court that he is no longer a representative of the defendant, and that all matters with.
When was that? What date was that, roughly?
Yes, it is in the skeleton.
13th or 14th of June.
Yeah, thank you.
So I was terminated by the company. I was representing in the capacity of an employee, and I was terminated by the company. And I updated this position to the court.
Thank you. Yeah.
Yes, I mean, this date is correct. It's in paragraph 12 of our skeleton. So once Mr. Khan made his position clear, Mr. Batrawi started making communications with us and the court in his capacity as the new representative of the defendant.
Yeah.
We explained to him at the time where the proceedings have reached, and that there is now a step that needs to be taken, which is to grant access to the software.
Yeah.
He requested for time, and we agreed. And a second consent order was signed, this time by Mr. Batrawi, in which he agreed on a later date to grant us the access.
Mm-hmm.
That date passed without Mr. Batrawi granting us the access. And then suddenly after that, we saw the entire shift in Mr. Batrawi's position with regards to the entire issue. Now, in response to why he cannot give access, he made a few arguments over correspondence. However, the position as it stands today, given that the permission to appeal application has been rejected, is that there is an outstanding order against the defendant that has not been complied with. So we need to look at things from that perspective. That's number one. Number two, our position is that Mr. Batrawi has not presented any argument that suggests why the court should change its position or not grant the unless order. So there isn't any evidence at hand, because even if the document is admitted, even if that submission is admitted, the only possible argument that one could make out of those submissions is that they were prevented from granting the access by way of an alleged order made by the Dubai Public Prosecution.
Yeah.
And to that, we say that there isn't a single document, there isn't a single piece of evidence that was submitted to show that such order was in fact made. The only document that was submitted was a letter issued by the Dubai Public Prosecution, which says that a complaint was made by the company against Mr. Khan for breaching confidentiality duties. And even if that was correct, we don't see how is that relevant to granting access to the software.
Can you remind me what page that letter is, or what bundle?
Yes.
Is it in your bundle?
It is. Just 1 second. It's at page 139 of the bundle.
139. Yeah, yes, yeah.
Yeah, so it basically says that prosecution certifies that on the 20th of June, and again, that is a date that predates the date on which Mr. Batrawi signed the consent order agreeing to allow us access. So when he signed it, he already knew that he had filed the complaint. All the prosecution says here is that a complaint has been filed accusing them of disclosure of secrets. The report was registered with the public prosecution, and the case is still under investigation. That's all it says.
Yeah.
So the only conceivable sound reason why they cannot comply with the order might have been if there was such an order by the prosecution, one might understand that might have been a good reason why they can't comply with the order. Yeah. But we know that it's simply not true. Yeah. So so that is so our position is that the only point that the court should consider is whether the order as requested is or falls within the powers of the court under the court rules. Mm-hmm. And we say that it falls perfectly within those rules. We rely on.
I'm in the meeting. No, after.
Mr. Travi, can you go on mute, please? So we rely on RDC 26.83 in this regard, which grants the general power for the court to direct a party to comply with an order or otherwise face a sanction.
Yeah.
So it is an
2682.
Correct.
Yeah.
So it is a general express power that grants Your Honor the power to do so. Secondly, our primary position is that the court that unless order should that the sanction should be that if the defendant continues to refuse to comply with the order, that their defense should be entirely struck out.
Yeah.
If and this is again an express power given to the court under RDC 4.20.
4.20.
Correct.
Give me a second. Yeah.
So yes, so as the court makes an order which includes a term that the statement of case of a party shall be struck out if the party does not comply with the order. So so that is our primary ask, Your Honor. And if Your Honor is not inclined to grant us the primary ask, then we've included 3 alternative requests that we would also like Your Honor to consider should you reject the primary one.
The primary one is basically that in default they be debarred from defending the case.
The primary one is that the defense is struck out and that judgment is entered for us. The first alternative is that that they should be debarred from defending the claim, i.e. that they should be prevented from relying on any evidence during trial. The third alternative, or the second alternative, is that they should be prevented from objecting or challenging the authenticity of the screenshots we've submitted from the software, because they shouldn't be able to benefit from their own withholding of evidence. If the expert and the court cannot inspect the software directly by way of the defendant's obstruction, then they shouldn't benefit from non-compliance with court orders. So these are the alternative we would like Your Honor to consider. Also, what we ask for is a daily penalty to be imposed on the defendant should one of the alternatives is selected.
What is the logical reason for rejecting the first one but granting the second or third?
What is that? What would be the reason?
What would be the theoretical justification for me to refuse the request for judgment, but allow, for example, make an order debarring them from defending the claim?
Our position is that our first primary position should be granted, because this is in essence what is being attempted by the defendant is to obstruct access to evidence, and we say that shows the truth that they know that if access is granted, then our arguments with regards to the deficiencies with regards to the softwares will be uncovered, and they're simply obstructing the entire process by doing so. You're on mute, Your Honor.
Sorry. Yeah.
Yes. So we say that if they continue to obstruct access to evidence and contravene their contractual obligations, because the matter at this point is not only about an application made under the rules. There are 2 consent orders signed, which constitute contractually binding instruments on the defendant, in which they agreed to give access. And if they breach these obligations, both legal and contractual, then we say they shouldn't be able to get away with it.
Yeah. You mentioned the 2 consent orders. One was 10th of May, and the other was a bit late.
No, the 10th. Sorry, no, the 10th of May was the CMC order.
Yeah.
The consent orders, I will look them up.
Yes. If you could just give me a page.
Yes, the dates are start on paragraph 18 of my skeleton. So the first consent order was the 28th of June, 2024.
And what page is that?
5 of the skeleton.
Oh, the bundle.
The bundle is 33.
Yeah.
And the second one, no, my apologies, I may have mixed up the dates. The first one was the 25th of June, and the second one was 28th of June.
Right. Okay.
Yes, and they're at pages 32 and 33 of the bundle. Yeah, so Your Honor, these are our submissions are, we say, very straightforward. The relief we seek is permitted under the rules, and the defendant has not made any submissions that tackle the points as presented, and therefore we urge Your Honor to grant them.
Yeah.
Your Honor, can I defend my side of the, if you allow me?
I mean,
in a moment, I'll yes.
These are all the submissions I wish to make, and I'm happy to answer any questions Your Honor may have.
If I was to grant the first part, you're suggesting I strike out the defence and then invite you as applicant to file a request for judgment.
Yes.
So that's a further stage of application.
I don't. I mean, I believe it can be made within the same order that judgment would be entered in favor of the claimant on the merits. I believe we don't need to make two applications.
What about the rest of your draft order?
Then it would fall away if Your Honor grants. If the first request is granted, then there would be no need for everything else.
Well, it may be granted, but then they may provide access, in which case you still want 3, 4, and 5, and so on, don't you?
Yes, correct. I'll just open the draft so we're on the same page.
I'm looking at page 49 of your bundle.
Yeah.
3, 4, 5, 6, and 7.
Correct. So three concerns. 3 would need to remain because it relates to case management should they comply with the order. And then 4 is the same. It's case management.
Yeah.
And 5 as well.
Well, leave out on or failure to comply.
Correct.
6, you want payment into court. Well, that can be discussed. And 7, you want costs of this application.
Correct.
Yeah, and just looking again at 2, what you really want is unless the one grants the applicant access to software by no later than. What date are you suggesting?
I propose as early as possible, so perhaps 1 week from today.
Well, I think realistically, you're not going to get before the court before the holiday period. If we said by 7th of January.
For the access to be granted.
Yep. Has a date been fixed for a hearing yet?
No.
There was a date fixed, and then it was vacated.
Correct.
Yeah. If we made it by 7th January, that would give a time for the defendant to get his act together, and it wouldn't delay you much because in the period between now and then, nothing much happens.
I don't object to this, Your Honor.
So 4 p.m. 7 January 2025. Yeah.
Yes.
The court shall strike out the defence and the applicant be invited.
What we suggest, Your Honor, is to obtain a self-executing order.
Which would say what?
That if they fail to comply, then judgment is entered on the merits of the claim in favor of the claimant.
So it'd be unless
objection, sir.
I'll come back to you in a moment. I'm finding out what they want first, and then I will ask you to respond. Unless grant access by 7th January 2025, the respondent's defense shall be struck out. Yeah?
Yes.
Out. And judgment entered.
In favor of the claimant as for the relief sought in the claim form.
Yeah. Yeah. And then that says all the further applications and so on. Yeah.
Yes.
Okay, well, I'll hear what is said now. Mr. Trafi or Mr. Hamza, I'm only going to hear one of. I'm going to hear one of you, but not both.
Before I give the honor to Hamza to talk, just let me just present. So first, we are objection against the execution of that because there is a already order to the honorable court that there is a criminal case, and as Mr. Bajamal said that before he deal with Mr. Asad Khan, so the request and everything, so it's addressed to Mr. Asad Khan. We don't know about this what happened in this order that there is a order for that. So for the bundle and case number 5, we go an order for public prosecution to stop give any software to anyone because of
where is this order?
Yeah, order is in documents.
Where is the document?
System E, number 5.
Number 5 of what?
For order.
Yes. What? I'm trying to find the document. Where is the document? The order.
Your Honor, the update on the order as of 4th of December, the case is dismissed already by public prosecution and the Y Court. The criminal case is dismissed already. We have won it.
Not dismissed. Still there is appeal.
I want to hear Mr. Trafi first, and then I can hear Mr. Trafi. What you say? There's an order preventing the disclosure of the document of the software.
Section E, Part E.
Of what?
Number 5.
Yes, sorry. Number 5 doesn't mean anything to me unless I know number 5 of what. Number 5 of what what bundle?
Of public prosecution.
Well, are you referring to this document?
It's yes, it's the supporting documents.
Well, I'm not finding this very easy, Mr. Trafi, because I don't know what document you're referring to.
In bundle case, section A, document number 5. It's mentioned in supporting documents.
Is what? Are you able
repeat
to
again? Bundle E, section 5, number 5. Section E, supporting documents.
Section E of what? Of what? Sorry, I'm finding this difficult. If you tell me what.
in the bundle cases, Your Honor, in the bundle case.
I'm going to ask Mr. Bajmal if he can help.
Yes, if I may help, Your Honor, the document that's being referred to is a document in the defendant's bundle, and I pulled this out. It's at page 150 of their bundle. Yes, it's at 150 of their bundle, and
right.
Just to simplify everything, it is a copy of the same certificate that we just went through.
Yeah, I see. Is this the document 20th August, Mr. Trafi?
Correct.
Yes, yes, sir.
And where
Yes, sir.
does that say that you can't? Where does it prohibit access to the software?
So still, and number 5, there is exhibition document number 5 mentioned that there is an investigation against Mr. Asad Khan, because he is the one who your honor court asking him to get software.
Yes, but where in this document, 20th August?
Yeah, because
Where,
your honor, the
sorry,
public
please.
prosecution is under investigation.
Well, yes, it's under investigation, but where does that prevent an order being made for access to the software? Nothing. Does that document say that the court should not make an order for access to the software?
So it's mentioned in this certificate 5. So
It simply says the case is under investigation.
no, I only mentioned that there is a case against Mr. Asad Khan, and is regarding this software. It's not allowed to. There is not a direct information from the public prosecution, because now it's transferred to Dubai court. So means that the order is redressing to Mr. Asad Khan and before, so but not for us. So the request was before addressed to Mr. Asad Khan. It's not for us.
Okay.
So we are not refusing to give in the software. It's already, as Mr. Bajamal said, that this request is addressed to Mr. Asad Khan before, and until me the time is Asad Khan is a part of our company. So means that till when we know about the case, that time we address the case to public prosecution for that, because software there is some problem and some issues, criminal issues. So that we need to see first of all what happened in this matter.
But Mr. Trafi, if I were I've been asked to make an order granting access to the software by a certain date. Is there anything in this document that you say prevents me making such an order?
We're making such orders, sir.
Is there anything to prevent me making an order?
Yeah, again, Your Honor.
Is there anything which says I should not make an order?
Because of there is a case against the person who was concerned about that. So we don't do any work. We don't have any software. Software is still there. Is under investigation between UAE and UK. So how I can give you software? Okay, you can give if Your Honor you will help us. So then you can give some letter addressed to UK, because there is another case in UK. Then we can give a software, because software source is from UK. It's not from UAE. And also we don't have access to as like a company. We don't have access.
Well.
So that's why I'm addressing the court, and I request to call in for the owner of the ELINX company, Bianca, is the one who still is representative of the company ELINX till now, as did some documents.
Well, I don't have any material before me at the moment which would make it inappropriate for me to grant the order sought by the claimant. So unless you can, what I can do is I can make the order that Mr. Bajmal wants me to make, but I could add liberty to apply in case you are able to show the court by the true date that you should not in fact have to produce grant access to the software.
Sir, can you give the honor to Mr. Hamza? He's the technician now in the company. He will talk about the server, how From where and from? So I give the honor to Hamza to speak about the software.
Mr. Trafi, this is a court process. The application is made in writing. There is an opportunity to respond to it in writing. You have not said any of this in writing.
Okay.
Now I will listen to Mr. Hamza for a moment, but you must understand that I cannot take into account matters that are not properly before the court.
Okay, Your Honor. Hi. Good
Mr.
afternoon.
Hamza.
Good afternoon. Can you am I audible?
Yes.
Okay. Can you allow me just 5 minutes to quickly take you through a quick run of what has happened, and hopefully we can come to a good conclusion here. You know, we are. I'll be very honest with you. I've been 17 years now in UAE, and I've not had any criminal case against me or any court case to date. Thank God. Apart from obviously this Muzoon case, which came to light. You know, it was actually active prior to us purchasing the company, which was happened in September 22. The case that was raised by Muzoon against ELINX INFOTECH happened in January 2022. Okay, the agreement was signed in June 2019 between three parties. There was Muzoon, ELINX, and Sharaf DG or Sharaf, IT company. Sharaf IT company was fronting this agreement, and obviously ELINX INFOTECH are to provide the software to Muzoon. I understand from the documentation that. Are you all right, sir? You okay?
Yes.
I continue.
Yeah.
So I understand from the historically that Muzoon has and obviously I had discussions with Mr. Asad Khan in the past, that Muzoon has actually renewed the annual maintenance contract multiple times, which means that the software was active and they were using it, and they were obviously updating the data. We have actually no question mark on their usability of the software. There was no issue at the time when they were using it, and I believe that was the reason why the previous cases. There was one case which was won by Asad Khan. So Asad Khan was with us in the company until September 23, and that's when he exited, and that's when I took over 100%, of the business. I got to know about the Muzoon case when Asad came from the UK in April 24. There was a situation, I think, in March 24, where maybe there was some sort of hearing where an expert was to be appointed, obviously to between Muzoon and obviously ELINX. There was a case when an expert needed to be appointed in order to investigate the software. We have actually no problem with that. That's fair. But Asad was representing ELINX at the time when he should not have been, and he was illegally representing us. He was not an employee, and he was neither a partner or neither he was on the license. So obviously this is very serious for the IFC to investigate, because between September 23 and until I rehired him in April 24, in that time he was not an authorized personnel to represent us, and neither we knew about this case. Should I have known about this case in the past, where it was supposed to be disclosed under the SPA on the basis on which we bought the company, I would not have bought the company, because we don't buy companies with legal cases. It does not make sense. I mean, you wouldn't, Your Lordship, would you? So now, later on, what happened, I had to come into the picture, because obviously this is a very serious case. They're suing for a large amount. What I'm saying is there is no issue with the software. Maybe Muzoon at a later time, they had issues because the software was, I'm not sure, it was not updated or there was an issue with it. We have no problem supporting Muzoon or Mr. Bajamel in any future requests that you guys have, as long as the software is on their server, which I believe Asad at the time when he was under ELINX installed it on their server. So if we are to do anything and to show them evidence of a software working, we can show them on their server, and obviously they have to pay for our developer to go back and update the software, because it's quite dated. It was an also. But if there is an order to access our system at the moment we are going through a legal case with Mr. Asad Khan and certain ex-team members, okay, where there was a hacking that has taken place into our server, and now the server is being restricted because the courts are appointing experts to come and investigate the situation. Okay, so we have absolutely no problem, supporting Mr. Bajamel. If the software is on their server, we're happy to go and update it. I have no issue. I'm not here to look. This case did not need to go this far. If obviously I came to know very early on about the situation and there was no criminal intent from Mr. Asad Khan, obviously, to hide this case, I am fully supportive. Muzoon would have been my client later on at a certain stage, and I requested to sit with Muzoon multiple times to resolve this. We don't intend to go into the IFC and have all these silly expenses going left, right, and center. But I know that there's a game between lawyers that they like to play. But really, here we are here to provide a software, and we are very honorable people. We are here to deliver a product as per what is mentioned in our specification. Yes, sir.
Mr. Hamza, what you say, I don't know, of course, whether you're right or wrong. You tell me one thing, and I'll be told other things. But the thing is, none of this is written down as part of your client's case, part of your case.
No, that's clear. What we're saying is we are not refusing access. If it is on their server, we're happy to go. But the problem is, what I understand from Muzoon, they have deleted their server. They have deleted the software. Now, if it is available, I will go tomorrow. I have no problem. But to access our server, there is still a case under Dubai court now being investigated. If you guys wish to wait,
why does that stop you giving access to Muzoon?
Because they are at the moment, what's happening is they are appointing experts to come and investigate the illegal access to an old server where the source code was. It's more complicated, Your Honor, because it's to do with Asad Khan illegally accessing our server in the past, and that now we have sanctioned that part of the server, because any manipulation to that server will probably come against us when an investigation happens and they send an expert to come and look into the different people that have entered the server, the different IP addresses, where did the attack come from? So it would put a lot of question marks, and we would probably get penalized. Why did you touch the server even though we have not finished our investigation? Of course, the case is ongoing. You can let Asad Khan defend himself.
If you have an order from this court requiring you to grant access to the software, then you can show that to the Dubai court.
Absolutely, I have no problem with that.
So why should I not make an order as requested by Mr. Bajamal?
No, you can make an order to access their server and update their software and get an expert to see it on their server. I have no problem. But it was sold and it was installed on their server. What these guys are trying to do now, they're trying to access our server. We did not sell them the software from our server. We sold it on their server. That's where it was installed, and that's where the data has been. Maybe Asad can confirm, because obviously historically, Asad, if you want to come in and support this, was it installed on their server or our server? You can clarify this to them.
It was installed in their server, but there is absolutely nothing to do with the criminal case that is going on at the moment.
No, I understand that, but I mean, it's not,
absolutely. Yeah. There's nothing to do with the criminal case that is going on at the moment. There are 150 clients that you have, and for them, you're supporting the software. So why you can't support it to Muzoon? I mean, probably I'm not sure if these are your.
No, we are not refusing to support
it intentionally, because all you have to do is just get an access, which Mr. Bajamal just confirmed a while ago that he provided access to their servers, and you have to update the software. What has it got to do with this criminal case?
No, because what happened is Muzoon are looking to access their software through our server, which we don't keep their softwares on our server. It was installed on their server, so we are happy to go and support them.
Mr. Bajamal just confirmed that Muzoon is willing to provide their server access. Mr. Bajamal, do you confirm that?
Yes, correct. We confirmed that months ago.
And then and Hamza, what you're saying is also incorrect. That all the Muzoon, the notices from claimants as well as the reminders from DIFC came on the company email ID info@elinxinfotech.com, which was under yours and your IT department's control. So you are not aware of Muzoon case is a totally incorrect statement.
No, we are not aware, and you were a partner at that time, you and Bianca. We were not aware.
I have a consultancy contract even after September 2023.
Okay,
let us just come back to the point of access. Your Lordship, if the software is installed on their server and it is functioning, showing a request for update, what I would request is Mr. Bijamal, maybe after this hearing, send us screenshots that it is actually on their server, so we don't waste our company time. If you can prove that to us, you can grant the access on the 7th. We will go and update their system. Of course, there will be a cost attached to that because this is an old system. We will go and do it, and we will show we will comply with any expert that you guys appoint in order to look into the history of the software. We have absolutely no problem. We are very compliant.
Okay.
So this is order, Your Honor. This is the order from the legal representative to Mr. Benjamin to do what our clients said.
Send us some screenshot that they have the software active, requesting an update. We will happily go and support our side and give some peace of mind to DIFC courts that we are, like I told you, sir, we are very honorable people. We are not here to hurt Muzoon or hurt anyone. We are a software providing business. So as long as they give us access and the data is still on their system fully, we will give full update, and we will even work with your experts, the appointed expert, and we will take them step by step on how our software work, and so we can at least get this, this case closed.
Yeah, are you done, Mr. Betrawi?
Yes, sir.
Your Honor, may I make a few comments?
Yes.
I'm not in a position to comment on these technical points about where the server, where the software sits. Is it on Muzoon's server, on their server? Because I have no instructions on this particular issue. And given the fact that it is being raised for the first time during this hearing without having submitted any skeleton, it would be extremely prejudicial to Muzoon for the court to entertain any of these arguments at this late stage, especially because there is no evidence submitted. However, with regards to the factual point as to whether the system does show a message saying that it needs an update, this fact is established by way of a screenshot that we submitted in page 78 of our bundle. If I may ask Your Honor to go there.
Yeah.
Yes. So this is the message that comes up when we try to log in to the software, and as Mr. Khan explained, he when he was made aware of this, he consented. He agreed that this is a simple update that can happen if access to my client's server is provided. And this was communicated to the other side, and these communications happened in May of this year. So I would like to ask Your Honor to approach the comments made by Mr. Betrawi with caution with regards to where the software sits, because simply we don't have any evidence to guide us on this point, and therefore I would object to any amendments being made to the draft order. The access is the access. So wherever that software sits technically does not matter. What the defendant needs to comply with is to grant access no matter where from and using whichever method applicable.
Mr. Bajamal, it occurs to me that there is scope for the matter to be resolved by a bit of discussion between now and the 7th of January. Sir. No, please don't interrupt. What I could do, what I suggest I do is this: change the suggested wording slightly. Paragraph 1, the application is granted. Paragraph 2 is to order the respondent by the 7th of January to grant the applicant access to the software, full stop. Paragraph 3 would then say, if access to the software is not provided by that time, then the claimant has permission to apply a 7 days notice for a judgment in default.
But I don't see what.
And that would give the defendants an opportunity to explain to the court, if there is a good reason why they haven't been able to give access, explain what has happened, and there can then be a coherent discussion about it. At the moment, the problem is that you've only just heard what has been said by the other side. I haven't heard that before. It looks as though there might be possible progress, and to have an order that is incapable of being complied with, or is uncertain whether it will be complied with, it doesn't make sense.
I respectfully disagree, Your Honor, because we've had months of these discussions, and Mr. Khan is present here today, and he was the technical person responsible, and he is confirming to this court today that there is no technical hindrance from granting access. Isn't that correct, Mr. Khan?
It takes only 10 minutes
What
for them to
about the
update.
signature?
It takes only 10 minutes for them to update the server.
There is no question direct, Your Honor. There is no question direct between you can't order to judge and make your question, Mr. Barjamal. So, Your Honor, so there is two documents showing that the job is completely signed by Mr. Asad Khan. So if you see number 8, bundle 5, 2 documents mention that Muzoon, there is 2 signature and stamp as well, that the job is completed and there is no issues, and signed by Mr. Asad Khan and the INFOTECH technical as well, Muzoon technical. So there is bundle number 8, 2 documents. We attach it in the documents, supported documents. Can you address this to Mr. Bajamal, Your Honor?
Your Honor, can I just add one thing very quickly, please?
Yep.
Yeah. So just coming back to the point. Look, I respect Mr. Bajamal's position. The software was installed on their server from 2019. It is active from 2020, and it's been always sitting on their server. So what I would suggest Your Lordship to do is, to give us permission to go and update their server, or their system. If they fail to give us access by 7th of January, please terminate this case and grant us the costs, and we have to win the case. Because why? Then they are failing to give us access to that, because the database and data is sitting on their server. If they can send updated screenshots with date stamps that there is an active software on there that requires an update, I am happy to go tomorrow. In fact, I go tomorrow. If Mr. Khan said 10 minutes, I will go for 10 minutes and update it to them. But they have to send us updated screenshots with timestamps showing that the software is active on their server, so I don't waste my time and I waste the court's time. And we should be granted that on 7th of January, by that time, if they don't give access, we should take the case.
Mr. Hamza, the trouble is that none of this case by the defendant has been set out before this hearing today. So there's been no opportunity of properly investigating what you say and how easy it is. So I don't think you're in a position to demand anything at the moment.
No problem. I'm just here to update, sir. I'm here.
What I anticipate, if I make an order that you grant access by the 7th of January, I would expect some contact tomorrow and the next day to see how possible that what the difficulties are, if any, and if there are no difficulties, then access will be granted straight away.
From our side, there's no problem. Can they grant us the access? Now the access has to come from them. We're okay with it. We're okay.
If access is not granted and it's shown to be the fault of the claimant rather than your fault, then of course you would not be liable for a default judgment.
Thank you so much. I'm okay with that.
Your Honor, if I may make a suggestion, we suggest that the order is granted as requested, and simply the defendant is given liberty to apply if there were any hindrances from the claimant side with regards to access. Then they would be at liberty to apply and explain this to the court, and then the court would see what's appropriate. The court can set aside the order or vary it. Or
that's another way of achieving the same result, I think. Mr. Hamza, is there any problem with that? In other words, I make an order that unless you grant permission by a certain date, and if you don't do it by the 7th of January, then there'll be judgment against you. But the next paragraph would say you have liberty to apply in case of difficulties caused or contributed to by the applicant in achieving access to software.
Your Lordship, I will add one more thing. The data is common sense. We are not allowed to keep any data of any client. The data and the software, they go together. Okay, so the data automatically sits with the software on the client servers. So, and what access I need to give, I'm not sure. If they give me access, like I said, I'm ready tomorrow to go and update it, and we're happy to support Muzoon in this case. I have no problem. We are here. Look, we are confident about our system and that it works. Maybe yes, there is an update that requires because it's an old software. So for experts to be able to test it, it needs to be updated. It's very logical. Please put in the paragraph, yes, if they give us access, I'm happy to go.
I think the suggestion I made covers all aspects. I must insist that we've had months of.
I appreciate that. But we're now in a position where we appear to be making some progress. Whether that is real progress or not, I can't judge. But and I understand why you have brought this matter before the court. But if having brought it before the court, we have achieved a measure of progress or potential progress, then that is a good thing and should be built upon rather than stopped. So,
understood.
Your Honor, the reason why we're not able to move forward is because I believe, I don't know, I can't make this claim, but maybe Mr. Benjamin, they have deleted the software from their servers.
I don't know. I can't possibly judge that. And
we need to confirm
if you had responded to the application much sooner and in more detail, like you have now, these sort of matters could have been understood and ascertained before this hearing. But you have not participated until this discussion now, and that is not something that the claimant can be criticised for. So, what
how do we move forward, sir?
Sorry.
So what is the way forward now? What's the next step?
What I propose to do is make an order in the form suggested by Mr. Bajamal, but with the addition of a paragraph saying that if before 7th January, you encounter difficulties in granting access to the software, which you say are not your fault, then you can apply to the court to change the order.
Okay.
All right.
Accept.
Sorry.
Sounds good.
Accept.
So what I'll say is excuse me. I'm saying this for the benefit of Alia, who is listening in, I think. Alia, can you hear me?
Yes, Your Lordship.
What I'm going to order is this. Paragraph 1, the application is granted. Paragraph 2, unless the respondent grants to the applicant access to the software by no later than 4 p.m. on 7th of January 2025, and in brackets, quotes, grant of access, close quotes, close bracket. Now, this is taken from page 49 of the claimant's bundle. then the respondent's defense shall be struck out and judgment entered in favor of the claimants for the relief sought in the claim form. Full stop. Paragraph 3, liberty to apply in the event of difficulties in granting the applicant access to the software. I'll put it as neutrally as that, and I hope it won't arise. But liberty to apply means you can apply to vary the order, all right? And then 4, paragraphs 3, 4, 5, and 7 of the draft order would follow from that with 1 or 2 bits of tinkering, which I will deal with when a draft is sent to me. Does that make sense?
Yes, understood.
Your Honor, I have one point.
Yes.
With regards to the additional wording, I would request that we add a text to indicate that that liberty to apply is in relation to situations where the access is prevented by reasons attributable to the claimant, because I'm afraid that I'm certain, actually, because of the defendant's previous behavior, that they will use this as another opportunity to say to bring about abstract arguments about why now there's another reason because of a third party in the UK or something that they're not able. We've seen their arguments shift drastically in the last few minutes, and I'm afraid this will be abused.
I'm not, Mr. Bergman, I'm not going to preempt any argument that's put forward, but I think Mr. Traffy and Mr. Hamza both know that what I'm looking at is something that makes it impossible for them to comply because of some position with the software, whether it's because you haven't updated, you don't have the data, or whether it's on their side, which is something that's happened and it's too late to change. I don't know. I'm not a technician, but I'm going to leave it open. There's no point in the defendants coming along and putting forward an excuse which is unrelated to the precise mechanisms of access. Do you understand that?
I understand your position, Your Honor. The last part of the draft order was the costs for this application, and we say the costs should follow the event.
We are objection of that. Still, Your Honor, just till now there is no subject for that, and so till now we don't have who is the responsible for that, or ELINX or persons. So I mean, there is an objection for the application.
Well, the problem is, Mr. Traffy, there's been several weeks or even months since the application was made, and this is the first time there has been proper engagement. So I'm going to order.
Your Honor, there is a reason.
There was a reason, Your Honor. We had
there is a reason for that.
We had a full Dubai court case against against our software company. So obviously
there's no reason why you couldn't have addressed the issues in a written response to the lodged in process, written response to the claimant's application. And
we have clarified to them, sir. We have responded that you're trying to access a software, you're trying to access a server, not only that we don't keep our clients' data. We don't. The software is installed on your system. There's an agreement for that, and it's been a sign off from Asad Khan on that. It's very, very clear. It's not from our side.
Well, I've heard the argument, and I've formed a view that the claimant the applicant should have his costs of the application to be assessed by the registrar if not otherwise agreed. What I'm omitting from the order, Alia, is paragraph number 6, which is as a condition of defending the claim, the respondents must provide a payment into court and so on. I'm deleting that from the draft order.
Understood.
And one more.
And in paragraph 5, Alia, just for your note, the registry shall, upon the respondent's compliance, and leave out the words or failure to comply. All right?
All right, understood. Thank you.
Thank you. Sorry, Mr.
Yeah,
Shafi.
one more request. So means that Mr. Assad should be a part of this case, because now we consider Belsons.ELINX, and there is a contract and many issues that we have to clear it. So you have to clear, Your Honor, in the judgment that's Muzoon versus Belsons and Assad and Bianca, like a previous company, ELINX company.
Mr. Shafi, litigation in the DIFC does not work like that. If you want to make an application to join someone as a party or to a particular application or whatever it is, you make an application in accordance with the rules of court. I'm not free to decide things which are not part of the process.
Okay, Your Honor.
Well, is there anything else?
Not from our side, Your Honor.
Well, thank you all very much. I think it may have been useful. I hope so.
Thank you, Your Honor.
Thank you very much.
Thank you.